Good evening, everyone. My name's Rachel, and I'm the marketing director here at Mackay Dressler Law Firm. We're so pleased you could join us today for estate planning for the LGBTQ plus community. So tonight's presentation will last around 90 minutes. We are going to wrap up with a live Q&A session at the end. So feel free to jot your questions down. If anything comes up before we reach the end of the Q&A, you'll be able to raise your hand and ask your question live, or you can type something in the chat button. First off, for some housekeeping, if you experience any technical issues during the webinar, you can send me a message in the Zoom chat and I'll assist you with whatever's going on. If you lose your connection during this Zoom, don't worry. You can rejoin us using the same link that was sent to you earlier this evening.
That was me.
Turn me off. Okay, so without further ado, I'll pass it off to Bridget, Mackay, and Miranda Dressler.
All right, thank you, Rachel. Good evening, everybody. I'm Bridget Mackay. This is my partner, Miranda Dressler.
Good evening, everybody.
We are the principal attorneys at Mackay Dressler. And tonight we're welcoming you here to kind of get some background for same-sex couples, LGBTQ plus community, estate planning. Just like any other couple, you have to plan for things. You've earned things, you've saved things, you've inherited things, and you have to figure out where all those things go when something happens to you or your spouse. So this is the purpose tonight, to talk about that for you, fill you in on things that you may not know. And as Rachel said, at the end, we'll be available for questions. So without further ado, let's get started. So it's fair to say, and we all know, that the legal history of same-sex marriages has been choppy waters. It's been illegal for a long time, then slightly legal, illegal, back and forth. But eventually, we nationwide were able to marry, same-sex couples could marry in 2015, and let's hope that it stays that way. So this whole programming is going to be under that premise. I know that we've got a lot of questions about what if it changes, ... and there are some answers to that. We can answer questions at the end. But right now, this is what the law is, and we're just going to give you some basic information and education around how to plan as a married same-sex couple. So one of the biggest questions I get, and this is even in the, cis world, like, do I need to actually have a plan? And I would say yes, generally across the board, people should have a plan. Most of us own homes, we have IRAs, we might have children, we have people we love and care about, and we want to control where our assets go. When we die, we also want to have some handle on how things are going to get dealt with if we are incapacitated. So pretty much all the same reasons that anybody else needs to plan. And we have to be careful with, the fact that discrimination against this community is still, alive and well, unfortunately. So the more protections you can put in place, the better. And these are very perilous times on many different levels. But even just for us in the planning world for families, we have one of the highest divorce rates in the country. This, believe it or not, we'll get into this more, does affect an estate plan and your assets and how they're inherited. We are looking at living longer, and as a result, there are more costs to living longer, particularly if we need care in that time frame. If you needed full-time long-term care in a skilled nursing facility, it could cost in California $100,000 a year or more. I know in Sonoma County, it's about $18,000 a month for care in a skilled nursing facility. And as a result, our family structures are more and more, I wouldn't say stressed, but called into action for care with people who are experiencing incapacity or a long-term health need. So this is just not hired help, but oftentimes family members, close friends, everybody plays a part. You know, it takes a village sometimes, as it does at the beginning of life, as it does at the end of life. And so as a result, a lot of families are facing the expense of care and what a long-term care need really entails, and the medical bills that, you know, spring up from these incidents. So many people are ending up in bankruptcies, or there's lawsuits because things weren't dealt with correctly, and families are ending up in court at a time that is very stressful already layered with decision making that literally at times are life and death decisions. And that puts a lot of stressors on a family. And my guess is that's why you're here. We want to remove the idea of court, of fees, of a poorly drafted plan ending up in litigation between family members or friends. We want to provide calm, have a peaceful transition for our lives and for the people that we love. So that is what we're doing here tonight. We can talk about how you can create that for your family and yourself. So stepping back a little bit, just in case this is the first time meeting Miranda and I just want to give you a little fact data about our firm. It was started in 2005. Between Miranda and I, we have over 30 years of combined legal experience. We are completely dedicated to planning, estate planning, and elder law. So this is, you know, these are the waters that we swim in. And a big supporter of that, or that supports our firm, is the American Academy of Estate Planning Attorneys, and I'll talk a little bit more about that in another slide. But we also are members of our local bar associations. Me personally, I've lived in Petaluma and Sonoma County for 25 years. I raised my daughter here. She's actually boomerang back in my house at the moment, so I'm still raising her here. Just kidding. And a couple of dogs, most recently Joey. So if you do end up coming into our offices for an appointment, you may meet Joey and possibly some other dogs. We are a very dog-friendly firm. So just to put that out there, because if you're afraid of dogs or allergic to dogs, please let us know, and we will happily accommodate that. Other than that, I love this community in different ways. I've been a part of this community and this county in general. Hand it over to Miranda to introduce herself.
All right, thanks, Bridget. Hi, everybody again. As already introduced, my name is Miranda Dressler, and here's some, fun facts about me. Been practicing law since 2009, and I actually joined this firm in 2017, and been working with Bridget ever since. Personally, a little bit about me. Our office is located in Petaluma. I also live in Petaluma, as does Bridget. I do not have any children, so I'm, single lady. I do also have a dog named Obi. And yeah, that's a little bit about me. I'll pass it back on to Bridget, but you'll hear more from me in a few minutes.
Awesome. Thanks, Miranda.
You're welcome.
So I mentioned the American Academy of Estate Planning Attorneys, and I think as a potential client, the most important thing you need to know about them is they are really a resource for Miranda and I to stay on top of, best practices and legal things all having to do with estate planning or elder law. And so we get extensive continuing legal education in all these areas, and also specifically for the LGBTQ plus community as well. So as best practices or laws are coming out, or the threat of, retracting laws like the marriage law or the Supreme Court case, we are really at the forefront and at the edge, and knowing when those things happen and having strategies for our clients to keep the plan that they had intended and have it go to the people that they intended, and really kind of fight off anything that may change that. We also have the resource of the 200 other firms like ours across the country that practice in the same way and are members of this group as well. And the very unique thing is about this group is they only choose one firm to allow membership to in a geographic area. So you will not find another academy firm in Sonoma or Marin County. That is only us. You're welcome to look them up at aaepa.com and check the whole group out. So I'd like to also tell any potential clients or people who are learning about this area of law that, you know, what we do often comes from the heart. Maybe that's true for all of us in life. We want to do things that are important to us. And for me, that is true. For Miranda, it is true. And the reason I do what I do, I feel is important that you know, so that you know where we're coming from as we interface with families and we help to support and protect them. And my story starts, like everybody's story usually starts, it starts with my own family. And the photos that you see on the screen right now, the black and white photo is a photo of my dad and I when I was young. And the color photo is a photo of my mom holding my daughter on her 3rd birthday. And that is where the story begins. My mother died very young of kidney cancer at age 64. So that birthday was the last birthday she was going to spend with my daughter. And that left my father single after a 42-year marriage. I am the youngest of 3 children. My parents were very much in love throughout their marriage, and we all knew it, and our family is very close. And so when we lost our mother, that was just a very huge impact, as some of you might understand. You know, when a mom leaves a family unit, there's a lot of glue that gets removed there. So in that experience, there were some concerns because my dad was still very young at age 66, that there would be a remarriage or dating or something in our future that would change the structure of what we always thought would happen. Would, you know, your dad dies, then your mom dies, and assets go to the kids. Not to say that when it happened, all we were thinking about is when is dad going to die and what's going to happen. But these issues came up because, you know, very soon after my mom died, my dad started dating, which was in and of itself a little difficult to swallow, but we're close and we knew he was suffering, and so it was fine. And he often said, to reassure us, I will never remarry. You know, my mother was my one true love, and nothing can replace that. And even though he had long-term girlfriends, long-term dating situations, eventually, you know, 10 years after my mom died, he really fell in love with his partner at the time and decided to ask her to marry him. So another fun fact about that, she was literally his next door neighbor. And he called us up all on a Saturday morning and asked our permission to marry her. We, of course, you know, luckily really liked her and were fine with it because he was just so happy about it. They married, but in the process of marrying, we had to have a real conversation about assets and the estate. All the assets in his trust were assets that he had accumulated with my mother, were inheritance from my mother's parents into it, from his mother into it. And we were the sole beneficiaries of it, yet he still wanted to in some way protect his new spouse. And so my brother, my sister, and I, my dad, and his soon-to-be wife had a lot of conversations about how this would all go down in case my dad died first and who was going to get what, and really trying to respect what his intent was for her and also preserving his intent and my mother's intent for us. And in that series of conversations, the plan emerged that if my dad were to die first, she would get his house because she was selling her house and moving in with him. And my brother and sister and I would get all the contents of the house. Everybody agreed to that. We knew that that's what would happen if something were to happen to him because he was a little older than she was. And, you know, that was the plan. Everybody signed off and it was fine. The unfortunate thing was he died within 18 months of marrying her. So he married her at age 76 and died at age 78. And this is where many families get into a fight, things fall out. nobody gets along. Maybe we could have been upset that she only, was married to him for 18 months and she gets our family home. All of those things I've seen in the 20 years of doing this. And in that moment, none of those things happened. We were a cohesive family. We mourned my father. We had adult education. We had adult conversations about how we were going to get all of the things out of the house that were our heirlooms, and that we transferred the house itself to her. And our family was able to make that transition without any animosity. In fact, to this day, we are still friends with her. She's a part of our family, as is her grandson. We spend, every holiday with them. We just celebrated her grandson's high school graduation, and everybody was there at the family house. So this is why I do what I do. After that long story, I want this for all of you. I want that transparency. I want that smoothness at a time of chaos where everybody knows what's going on, and I want to preserve those future relationships that you have in your life. So that is why I do what I do, and we're going to roll into sort of what your concerns are. So these 7 concerns I'm going to go over, Miranda and I have accumulated over meeting with hundreds of clients. So these are sort of the common areas where concerns show up around estate planning, money getting transferred, inheritances, incapacities. The first 2 are financial. So most people understandably want to reduce any future court costs, taxes, things that will take away from the estate. Sorry, the first concern. The second concern is we want to make sure, particularly in the LGBTQ plus community, that there is a clear plan about medical decisions, visitation, who is in charge of a partner's health decisions. And then we also want to avoid any fighting that occurs after someone is gone, because that can be a common thread. And then the fourth concern is really for that next generation, whoever is inheriting the assets, whether that be a partner, whether that be children, beloved nieces and nephews. We want to make sure that those recipients are protected from any creditors that they may have or predators that are in their life. And believe me, some of those predators are people that are close to them, like a spouse. Another huge concern we see is the cost of care. We all know, living in California, that just kind of goes up day by day, and whether it's at the forefront of your fears or the back of niggling fear in the back of your mind, this is a concern that we hear about and need to address. And then the sixth concern, which is dear to my heart and Miranda's heart and all of pet friend hearts for children, is that you want to protect and make sure that there is care if there are small children and your pets if you were to die or become disabled. And then the seventh concern is maybe something that you don't know how to voice, but we see pretty regularly, is this kind of devotion to make sure that you are passing on your values. You are a good steward for your assets and for your family and your friends, so that you leave some sort of legacy for them. That is really what we're after here, and most of our clients are after doing. So those are the 7 major concerns that clients have and that we need to be aware of and that we want to solve. We're going to address all of them tonight. We're also going to address something that we see very often too, which is you get all of this education, it is all in your head, but you get somehow vapor locked or immobilized to get into action. So as part of this programming tonight, you are also going to get a step-by-step playbook of how you can get into action and create a plan for yourself and give yourself and your family peace of mind. We really do want to congratulate you tonight because the topics we're going to cover are very hard to talk about and are often not talked about. So it takes some courage and some bravery to sit through this and really try and apply it to your own life and address it from the heart. And really, I'm encouraging you tonight to think of the situations we're going to talk about and see what it feels like and looks like if that were you in that situation. Because that really is what it's about here, is what are you going to leave for your family and your loved ones and your partner? The number one reason people don't plan is that very reason. They aren't willing to sit through this 90-minute presentation and get questions and educate themselves. They feel like they have time. It's the human condition. We are eternally hopeful, no matter what we might be thinking about right now. We are hopeful that we're going to live a long time and that we might have time to do this later. And what I'm here to tell you today is you are not going to have time to do it later. This stuff can't be done when the events have already happened. And that's the second reason people don't do this also, is they lack the knowledge, which I'm going to tell you right now is, you don't get what may happen, and we're going to help you understand tonight and give you that knowledge that you need to pre-plan this stuff. Because when that incapacity or that stroke hits, or that decline in mental capacity, or you have a sudden death, there is nothing else that you can do to make this process smooth for everyone else. In fact, you have made it much more complicated than if you had left a plan. And it's almost particularly more important for the LGBTQ plus community because so many other people can step into roles that you never had wanted that to happen with, or be that person to be in that role. So I want you to think about this planning from a different perspective. Many people come at this as like, my CPA told me I need to do this, or my financial planner told me I need to get one of these things in place, or my dog park friend. But the truth is that this is a heartfelt work, because when this stuff goes down, if you can take the thought of this happening from the brain into the heart and really see, if you do nothing or you do something poorly, how it's going to affect your loved ones if you don't wake up tomorrow morning, or you wake up and are unable to handle your financial affairs or make your own health decisions. What kind of chaos and fear and all kinds of other things that come into the lives of your loved one. And for selfish reasons, you may not be treated the way you had intended to be treated. So we want you to come at that like this and in those terms and really look at it from that mindset. Because we all have defining moments in our lives that shift our lives in a different direction. And they're often these emotional anchors that we rely upon throughout our lives, whether they're special days like births of children, grandchildren, wedding days, or difficult things where you either experienced a loved one having capacity or die. We take something out of those. And I think, and that's why you're here tonight, want to make this a smooth experience for your children and your grandchildren or your spouse or your partner or your pets or any loved one in your family. And what we have found is that often traditional planning does not satisfy all of the needs and create a smooth transition for your family. It's not that traditional planning is bad, because it does cover some very good things like controlling distributions, eliminating probate fees, and avoiding court costs. But what we have found, particularly with the LGBTQ plus community, is that there are a lot of other soft issues and considerations that are in these family groups that isn't addressed. And when they aren't addressed in the plan, these plans end up with heartache, fights, and worst case scenario in court. So that's why Miranda and I approach this very differently. We have a much more holistic view of how to create an estate plan and for families and family groups in this community. And it is to start with those core values. What are your deepest beliefs and values? What is important for you to protect? Who is important for you to protect? And then we add those financial pieces to support this plan around that ideal. So we call this legacy wealth planning because we really start with the client and their family group and make a determination of what's most important to them, and then create the trust or the estate plan to support that. So it's really important for you to start thinking about that, even in this educational webinar tonight. What is one of the most important or several most important ingredients that you want in your plan? What are priorities there? Because if we don't start with that and we just kind of get something off the internet for a plan, or we do traditional planning, or worst case scenario, you'll learn this term, a bare bones trust plan or a bare bones estate plan, then a lot of things can go wrong. Usually there's poor documents that aren't capturing the legacy that you want to leave. When a family finds themselves needing long-term care, the support is not there to both energetically and financially support a loved one, but also there could be a loss of assets because of it that could have been protected. Oftentimes there is no funding, and we'll talk in more detail about that, but a plan is created, but there are no assets that support that plan. And one sort of myth out there is that you get your plan done and put it in the safe deposit box or the file and never look at it again. Well, that's simply a bad way to go about things. So we emphasize timely updates. And so that leads into making everything current in that plan so it is ready to manage, one of these journeys in life. A guaranteed one is a death. So, and a lot of things aren't captured in these plans, the ones we see failing. And it just brings more chaos and concern to the family. So these are the things we want to avoid because we know where plans fail. I'm going to hand it back over to Miranda. She's going to dive into some of our educational piece. I want to make sure, oh shit, what did I do?
It's okay, I can reshare.
Okay. But she's going to go into what it looks like to plan and how it can be beneficial and what can go wrong.
Okay. Thank you, Bridget. I think we're back on. Yes.
Thank you. Yes.
All right. So hi again, Miranda here. We're going to kind of, go into the more of the educational, nuts and bolts a little bit portion of tonight's presentation. And so really to help you all kind of understand the issues that we're discussing tonight that you may confront, and particularly in the LGBTQ plus community, has some unique kind of issues to navigate. We're going to take you through the story of two separate couples. Okay, we have Mark and Jason and Liz and Alex. So our first couple, Mark and Jason, have been together in a relationship for quite a long time, about 15 years. And they were actually married in 2013 once that became nationally, legalized. Our second couple is Liz and Alex. They've also been together for a long time, about 20 years, but they are not legally married or, registered domestic partners. They did have a commitment ceremony that was more, several years ago, but that wasn't a legal ceremony. So they're together life partners. Okay. And we're gonna, kind of go through each of these and we'll see how like different types of estate planning can affect the result of kind of what happens in people's lives. Okay. Both of these couples have, worked hard, had careers, kind of accumulated assets. And both of them, think that maybe their estate isn't necessarily all that large. But they do have, things like a home, retirement accounts, some savings and investments. And so
in our story tonight, we estimate that each couple has a, kind of net worth around $700,000 or so. Maybe a low estimate from today, relatively low estimate from today's standards, but that's what we're going to go with in our example. So if you are listening tonight, you're like, but wait, I'm not married or in any kind of a relationship. So if you are listening and you're single, whether that's, you're divorced or widowed, or you've never been married, or you've been married multiple times and divorced multiple times, whatever the situation is, if you are not in a relationship, please don't fret. We are using kind of couples as an example, but really 99% of the concepts that we're going to be talking about tonight do apply to you. So don't stop paying attention, find yourself in these examples. Okay. All right. So, as each of our kind of fictional couples embark on, looking at getting an estate plan done, because that's where each of them are at, right? They don't have anything in place and they're looking at getting their affairs in order. And, when people start looking into getting their affairs in order and like, what are the options that are available out there, it can be kind of overwhelming. Because there are a lot of potential options that are out there, and there's a lot of information that is out there once you start kind of Googling it or asking, AI, which I think is more common these days. So I'm going to go through it. And by the way, not everything is applicable in every state. So a lot of information online might be true in one state, but it isn't necessarily true in California. So it's confusing. So I'm going to go through and just really summarize the most common estate planning options that are out there for people that you see listed on this slide. So kind of the first two options are really the same thing in a way, which is like the first being spend every last dollar. That's kind of like, I'm not going to do an estate plan because I'm just going to spend all my money. I'm not planning on leaving an inheritance to anybody. Really, that's basically the same thing as the second option, which is called dying intestate. And that really is just a legal term for dying without any kind of written estate plan. That's a little bit of a misstatement, though, because in fact, everybody does have a plan. If you don't come up with your own estate plan, a will or a trust or something like that during your lifetime, the state of California does have a plan for you, and that will step in and dictate who inherits your assets. It also will step in and dictate like who can step in to manage things for you if you become incapacitated at some point. So, really having that attitude of I'm just going to spend it all really doesn't work, because you really give up the right to decide for yourself what you would want to have happen. The third option on this list, which really is not actually an estate plan, but it's kind of a strategy that sometimes people use, is to put assets into a joint tenancy. And a joint tenancy is just a way of owning an asset where there's two or more owners, and there's something called a right of survivorship. So when any of the owners die, the asset belongs to the surviving owner, right? So a lot of married couples hold title this way, for example, to their homes. But, if you take anything away, or one of the things you should take away from tonight's presentation is joint tenancy really is not a long-term option, right? Especially if we're talking about a couple, once the first spouse passes, now the surviving spouse or partner is the only owner. And so that they do nothing and they later die, they will have died intestate, right? Without any type of plan. So then the fourth and fifth and sixth options are really where we're focusing on tonight. So the fourth option being creating a simple will. And that's really the most popular option of this type of estate plan still in this country. I think probably everybody's heard of a will, usually what we think about when we think of estate plans. And, a will really is just a legal document where you name an executor. That's the person who you're naming to handle and carry out your wishes at your death, basically, and handle the administration of your estate. And then it's where you name who your beneficiaries are. And we'll see with the example of our first couple, Mark and Jason, because this document, this type of estate plan, a will, is going to be what they initially decide to go with as far as estate plan. And so we'll see with their example that a will really brings with it a lot of consequences in the way that it works that a lot of people, I think, aren't really aware of. And then the fifth and sixth options on this list are to create a living trust. As Bridget kind of mentioned earlier, that we see basically two kinds of living trust. One we refer to as a bare bones living trust, and that's really like a cookie cutter document. You could get for very inexpensively, sometimes almost like for free on the internet, and your names are inserted into the appropriate places, but that's pretty much it. It's not in any way customized for you. The main point of that trust is to try to avoid probate at death, and we'll talk about what probate is momentarily. But in our experience, bare bones plans really don't even do that much of the time. So then really the kind of opposite of that is just a much more comprehensive and thorough living trust that is designed specifically for you, your family, your concerns, and the things that are important to you. Really making sure that it covers everything that it needs to cover. All right, so we're going to go into the, more detail about our first couple, Mark and Jason. Remember, they're married. They've been married since 2013. They both are still working, but they're heading towards retirement. They're pretty close. And as I mentioned earlier, they have a total of estate that is about $700,000 in value, which really consists of their home. They each have a couple of, bank accounts in their names, including like some retirement accounts from their employment. And then Mark actually has an investment account that he inherited several years ago from his own parents. So that account is just in his name alone. So that's kind of a summary of their assets. Mark and Jason don't have any children, but they do have some, family members. So you can see here pictures of them. Let's see, Jason has a sister named Beth. That's the lady in the green shirt. He's really not close to Beth. They are kind of estranged somewhat. But he is close to Beth's two children, his niece and nephew, and that's Stephanie and Andrew that you see up on the screen there. Stephanie is kind of the good girl of the family. She's always done well, abided by the rules. She's successful. She's married herself at this point, and has two small children of her own. Andrew, on the other hand, has had some struggles in life. He's had issues with things like addiction, and he's currently seems to be doing better and heading towards the straight and narrow. But Jason and Mark are both kind of concerned about what might happen with Andrew over time, particularly if they include him as a beneficiary in their estate plan. Like, is he going to dwindle away any inheritance he receives? Is that going to be like a negative thing for him to receive? All right, so that's a little bit about Mark and Jason and their family. So as Mark and Jason are kind of looking at this next phase of life, right, heading towards retirement, getting their, affairs in order, they put together a to-do list of some of the things that they want to accomplish as they go kind of into this retirement phase. And as I mentioned, one of the tasks that they have decided to do is have their wills prepared. But they're actually still procrastinating on that a little bit. I think you can see the will, create a will is there on the to-do list, but it's not quite at the top of the to-do list. What is really important right now, at least for Mark, is that he start a new exercise routine. He's been sitting at his desk his entire career, and he would really like to get in shape, get in better shape, and have a really active, just start to be more active as he goes into retirement. Be active, be healthy, have a long retirement that he can enjoy. So he launches himself into a pretty rigorous new exercise routine. Unfortunately, he doesn't really take that one piece of advice that they always tell us to do before starting any new exercise routine, which is consulting with the doctor, right? So something happens. You might think that he, passes away, but in fact he doesn't, but he does wind up having a stroke. It turns out to be a pretty minor stroke. He spends a few days in the hospital, but he's able to go home. But this is a big wake-up call for Mark and Jason. And, they say to each other, okay, we got to go get these wills done, right away. The wills have now become a priority on the to-do list. So they reach out to the only attorney that they really are familiar with. That is a real estate attorney that helped them with the purchase of their home many years ago. And they asked that attorney, we need to get some wills done. Can you help us? And that attorney says, well, it's not my usual practice area. I'm a real estate attorney, but a will is not that difficult. I've done it a few times. So sure, come down to my office in a few weeks and you can each sign your will. So that's what they do. A few weeks later, they go down to that attorney's office, and both Mark and Jason each sign their own will. And, Mark's will leaves everything to Jason, right? And as long as Jason survives him. And then if Jason doesn't survive him, he leaves a portion of his estate to charity, and then the rest of it to the niece and nephew, Stephanie and Andrew. And Jason's will basically says the same thing, but everything to Mark first. So they get those wills done. They put the wills in their safe deposit box. They check that box off their to-do list, and they feel good about it. They feel like they've done what they're supposed to do. They've gotten their estate plan done, check, and they go on with their lives. Okay. Unfortunately, about a year or so later, Mark winds up having another stroke. And this time it's really a much more serious stroke. He does survive, but he becomes what we call incapacitated, really like disabled and unable to care for himself any longer or kind of make decisions, financial, health, etc. So we're going to talk a little bit at this point about what that looks like in terms of long-term care and specifically long-term care expenses. What is long-term care? How expensive is it? And the most important question is, how do we pay for it? As Bridget mentioned at the beginning of the presentation tonight, we are living longer. Diseases of aging are much more prevalent, I think, because of that reason. And a really large majority of us are going to need some kind of long-term care at some point in our lives. I think the statistic is like over 2/3 of us will need long-term care at some point. So it's important to, talk about this. And this piece is a really important piece to estate planning in general. So what is long-term care? There's varying, that's a general term. There's different kinds of long-term care. There's, in-home care. That's having someone come into the home to do the things for you can no longer do. There's day-to-day places like adult daycare centers. So if Jason was taking care of Mark primarily himself at home, but he needed a break for the day, he could drop him off at the adult daycare center and come pick him up at the end of the day. There's assisted living facilities. So those are like, independent living, but there's a higher level of kind of care and services there on site. And then really the highest form of long-term care is care in a nursing home, otherwise known as a skilled nursing facility. Okay. All of these options are very expensive. In-home care, especially if it's needed 24 hours a day, 7 days a week, can be the most expensive. I was just talking to some clients a couple weeks ago who have a live-in caregiver. It's costing about $150,000 a year for that. Assisted living facilities average probably between $5,000 and $7,000 a month, although they can be more expensive. And nursing homes, can be between like $13,000 to $18,000 a month. So they're all very expensive options. And as we said, that are becoming more common. So how do we as Americans and Californians pay for these expenses? There's really just 5 ways to pay for long-term care in this country. And unfortunately, the most common way to pay is just right out of your own pocket, what we call private pay. right out of your retirement savings, your inheritance, whatever you're kind of relying on to take you through the next phase and final phase of your life. So at over $100,000 a year in many cases, I think you can imagine how quickly your assets can, really be fully used and dwindle from that. And we'll see that this is the most common way that people pay because the 4 other potential options aren't necessarily an option for everybody, and can be, difficult, if not impossible, to achieve. So then the second potential option for paying for long-term care, and in Mark and Jason's example, if they had done some planning ahead, would be to buy long-term care insurance and hope that this has enough coverage to, pay for the care that is needed in this situation. So this is something that can be a good option. There are a lot of different products these days that are out there in terms of long-term care insurance, but it is something that you have to get earlier on, like in your 30s, your 40s, maybe your 50s, because the older you get, the premiums become prohibitively expensive. And once an event happens, like with Mark and Jason, like it's too late. They're not going to be able to get long-term care coverage at that point. All right, so then the third potential option for long-term care is really a very limited option, and that is Medicare. So we probably all heard of Medicare, which is basically health insurance for people who are age 65 and over. It's a government program, and it pays for general things like doctor's visits and prescriptions and things like that, and a very limited coverage for long-term care needs. So in Mark and Jason's situation, when Mark has his stroke, and let's say he winds up in a nursing home, like for a while, recovering from that stroke, Medicare might cover up to 100 days of his stay there. It's actually very unlikely that they would cover that much, but certainly anything beyond that, they are not covering. So for truly long-term illnesses and like events, Medicare is not a long-term option for people. And I think there is a lot of confusion out there that people think that Medicare is going to somehow just cover them for long-term care needs when it really doesn't. So then the fourth potential option for paying for long-term care, which sounds similar to Medicare but is a different program, is called Medi-Cal. So this is California's version of the Medicaid program. And this is a joint federal and state program. It's administered, county by county. It's actually the program in this country that pays for the majority of long-term, primarily nursing home expenses for people in this country, which is great. But Medi-Cal, not everybody can qualify for it because it's an asset-based program. So the idea is that you generally have to spend down most of your wealth and be almost kind of broke before you can qualify for Medi-Cal to step in and like pay for a nursing home cost. Okay, I'll touch on this probably briefly a little later on. There are ways to do some planning around this. We're not going to get too deep into it in this seminar, but that's generally though how Medi-Cal works. And then finally, if you are a veteran or the spouse of a veteran, there is a program through the VA, the Veterans Administration, called Aid in Attendance. And that is a program that doesn't only necessarily cover nursing home expenses like how Medi-Cal is kind of focused on, but it is similar to Medi-Cal in that they have asset limits, right? So it's meant for financially needy veterans and their spouses, and you kind of got to spend down the majority of your assets before you can qualify for that program. So those are the ways that we pay for long-term care in this country, and it is a little frightening and a little bleak, frankly. And to show you how this often can play out in a family, I'm just going to take you actually quickly through the story of Elliot and Edward, who are Mark and Jason's next door neighbors, okay? So Edward gets diagnosed with dementia, and Elliot takes care of him himself at home, really for as long as he possibly can handle it. But ultimately, he's not able to, do it all himself anymore. And so Edward is admitted to the local nursing home, and that's where he stays for about 37 months until he passes away. And Elliot really, spends the majority of he and Edward's savings on Edward's care at that nursing home. And when he kind of finally gets down to like the bare minimum, he's able to have Edward, qualify for Medi-Cal, and then Medi-Cal comes in and pays for the final 10 months of Edward's care at that nursing. Okay. So after Edward passes away, Elliot is kind of stuck between a rock and a hard place. He's spent down the majority of their savings on Edward's care. And so he's really just left with their home, because that's not something you have to spend down or sell for medical purposes. He's really just left with the home and his Social Security payment coming in. And to add insult to injury, years later, when Elliot eventually passes away, there really may be kind of nothing left to pass on to their two kids, because this is actually when Medi-Cal will come back into the picture and do something called recovering against Elliot's estate for everything that they paid for Edward for his nursing home care while he was alive. So what this looks like for Elliot and Edward's family is, they get a notification from Medi-Cal that this huge amount of money is owed and they have to sell the house, and Medi-Cal takes a big chunk of that. Now, a silver lining here is that I think it was 2017 in California, basically passed the law that Medi-Cal can only do this, like recover against the estate of a person who received Medi-Cal during their lifetime, if that person's estate goes through the probate process. So we're going to cover that, what that is, in just a minute. But basically, if there's no probate when a person passes, like if you have a living trust and you're a Medi-Cal recipient at some point, they won't be able to come back and recover against those assets. Okay. So that was a little bit about long-term care, how we pay for it, what that kind of looks like. Circling back to our, main story, our main couple of Mark and Jason. Remember, Mark has had this major stroke, and he's become disabled, unable to manage things, pay bills, really do anything. Okay. So how does Jason, as his spouse, step in for Mark to make decisions and things like that? And does he have the legal authority to do that? And remember, you may or may not remember, when I was describing Mark and Jason's assets kind of at the beginning, I mentioned that Mark had an investment account that he had inherited from his own parents. That was just in Mark's name alone. And right now, Jason really needs access to that account. It contains a pretty, good amount of money that Jason needs to use for, to pay for some care for Mark. But if Jason goes down to that financial institution, let's say at Schwab, and says, this is Mark's account, but I'm his spouse, he's had a stroke, he is disabled, I need to access this account. Well, they're not going to talk to him. It's not his account, his name is not on it, and it doesn't matter that he is Mark's husband. If he pulls out, Mark's will that says, well, look, I'm named as the executor in Mark's will, that doesn't matter either, because a will only goes into effect once someone has died. And because Mark is still alive, the will is meaningless, pretty much. So, Jason is going to be kind of in a tough position here. And really the only option in this kind of a scenario for Jason to get control of like Mark's assets and really be able to make legally, like make decisions and manage his things on his behalf, is going to be to go to court and go through something called we refer to as a living probate. It's technically called a conservatorship. And this is a court process that is designed to protect people who are mentally disabled, right? What incapacitated, whether that's because of dementia or a stroke or whatever reason someone cannot manage their own affairs. And it is a court process, where basically what that looks like for Mark and Jason is Mark is going to be pronounced incompetent to handle his own affairs. Jason's going to have to disclose all of their kind of personal financial information to the court. And then after some, time, Jason likely will be appointed as the conservator, which is like the decision maker for Mark, because that's really the purpose of a conservatorship, is to appoint someone who steps into that disabled person's shoes and can then act on their behalf. Even though it's likely he'll be appointed in that role, make no mistake that anytime the court becomes involved, and especially in a conservatorship, it's now the court that is in control. And Jason is actually going to have to account to the court for every penny that he spends out of that investment account or any other assets of Mark's that he's managing, so the court can make sure that money is being spent properly and for Mark's benefit. That's really the purpose of a conservatorship. And we know that anytime we have to go to court, it's going to be kind of oppressive, burdensome, stressful, long, expensive process, right at a time when that's like the least thing, the last thing that someone in this position, right, needs to be dealing with. So Jason goes through that process because he really doesn't have another choice. And after a few years, Mark ultimately does wind up passing away, from complications from this stroke. And this is then finally when the estate plan that we talked about at the beginning, the wills, are going to come into the picture, right? And if we remember, Mark had a will, and Mark's will said that at his death, if Jason survived him, that all of his assets would go to Jason. However, in order for all of those assets to actually go to Jason, and particularly something like that investment account that just had Mark's name on it, right? That was just Mark's account. Jason is going to likely have to go through another court process. We refer to that as death probate. We actually refer to it as just probate, but in this presentation, death probate, because we distinguish it from living probate. So I often have clients ask, why is this necessary? Why has a probate process become necessary? And a lot of people are surprised that a probate would be required when a person has a will, and it certainly is. But the question is, why is probate necessary? Why does it have to be so complicated? And it really comes down to how you hold title to your assets. So if you think about it, when you are alive and you own an asset, your name is on title. If you were to transfer that to somebody else, you would sign some kind of document to do that, right? Changing the ownership. When you die, you're obviously not there and able to sign a document to change title any longer. And so the only institution that is authorized basically to change title of an asset from the name of a deceased person to those who are rightfully inheriting, like under a will, is the probate court. That is, at the end of the day, why probate becomes necessary. And so what happens in a probate is the court will resolve any disputes, if any arise. If there are any creditors, they need to be notified and ultimately paid. The assets would be inventoried for the court and appraised. And then at the end of the process, the court would order those assets be distributed in this case, to the beneficiary named in the will, Jason. And the court would order that then title to the asset be changed into Jason's name. So at the end of this process, Jason is the intended beneficiary and he will end up with the assets. So why do we want to avoid this process? It's really something we hear day in and day out of, why people want to plan is they want to avoid the probate court process. And it's not any different of a reason than why we would want to avoid any other type of court proceeding. It's expensive and it's time consuming. That's particularly true with probate in California. If we're talking about the time frame, the typical probate Takes about a year to a year and a half to complete. That is if everything goes smoothly. It can take much longer if there are issues or, disputes or anything like that. And then the cost of a probate is really, really high. It doesn't come from, sometimes I get, is there a probate tax or something like that? And there isn't. The cost of a probate really primarily comes from the attorney's fees and the executor's fees, because those fees are set by law. So it's really not something that you can negotiate. And they're based on a percentage of the value of the assets that are going through the probate process. So as an example, if we have like an $800,000 estate going through the probate process, the attorney's fees are going to be about $22,000, and the executor's fees are going to be that same amount. So, right off the top, that's almost $50,000. So it can just be very, very expensive. There's also the possibility of having to have multiple probates, because if the person owns real estate in any other state, the California probate court doesn't have jurisdiction or the authority over real estate located in other states. So someone would have to go into each and every other state in which that person owns real estate and open up a separate, what we call an ancillary probate proceeding, which, adds to the expense and the delay. All right, so after Mark's death, that's a little bit about probate, right? Why we wanted to avoid it. What about taxes, right? So Jason goes through the probate process. He, inherits the assets from Mark. Is he going to owe some kind of big tax bill because of that? So here we're talking about two potential kinds of death taxes, right? A state death tax. Luckily in California, we do not have one. And then there's the federal estate tax. And really how that works is, when a person dies, the IRS wants to know the total value of the assets that that person owned. And if that value surpasses a certain threshold amount, called the estate tax exclusion amount, then the overage is subject to estate taxes. Now, in our example for Mark and Jason, this is not a concern, and it's really right now not a concern for most people, because the estate tax exclusion amount is currently $15 million a person. So that's how much money each person can have before any estate tax would be imposed at their death. So not something for Jason to worry about. He's really not going to have to worry too much about taxes. But ultimately, we can see that, the estate plan, the will that Mark had, really hasn't provided much protection or smoothness at all for Jason, right? It didn't do anything while Mark was incapacitated, and it really didn't avoid any kind of court process after Mark passed away. So after Mark's death, then, Jason now is their surviving spouse. There may be a couple things that him or the family, like his niece and nephew, might be concerned about. Like, he's inherited the entire estate from Mark. What if he decides to remarry at some point? And then what if he himself winds up needing some kind of long-term or nursing, long-term care, nursing home care? And how is that going to be paid for? And speaking of remarriage, remember Elliot. He's Mark and Jason's next door neighbor. He recently lost his husband, Edward, from dementia. He's kind of, destitute. He spent down most of his assets, and so was mainly just living on Social Security. And who knows, he and Jason could strike up a friendship and a relationship. And maybe, Jason feels bad for Elliot, and he decides to go in and change his will to leave half of the estate or the entire estate to Elliot. Who knows? At least there's nothing preventing him in this, setup from doing that. If this issue had been discussed with Mark and Jason while they were drafting their estate plan, their wills, there is a way that the documents can be drafted to prevent Jason from basically changing what ultimately happens with Mark's share of the assets. But that's all something that you have to do in advance while both parties are still alive. At this point, once Jason inherits and it's just him, if he decided to change his will, there's really nothing anyone could do to prevent that. All right, so as I said, now Jason has inherited the entire $700,000 estate from Mark, and he lives about another 10 years or so after Mark's death. And during that time, he really, invests that money pretty wisely, doesn't spend wildly. And so that $700,000 estate value during that 10 years winds up doubling to about 1.4 million. Unfortunately, about 8 years after Mark's death, Jason does develop Alzheimer's disease and becomes incapacitated. And so his niece and nephew, Andrew and Stephanie, have to kind of step in and try to place him into a nursing home, right? They can't care for him themselves. And he's placed into a nursing home pretty quickly. So he is now unable, incapacitated and unable to handle his own affairs, right? So who has the authority under Jason's estate plan, his will, to step in and manage things for him? Like the house, for example. What if the house needed to be rented out? What if it needed to be sold or refinanced? Does Stephanie or Andrew have any authority to, I know they're beneficiaries eventually of his will, but do they have any authority to step in and manage things now? And the answer is that, if we remember the example with Mark, no, right? A will only goes into effect at death. It has no effect at this point. And so, one of these family members, whether that's the niece, the nephew, or even the sister that Jason was not close to, are going to be back in court, kind of going through the conservatorship process, just like Jason had to do for Mark. Now, and here's the thing in this kind of situation, like, we don't know who the court is going to choose to be in that role. It very likely could be the estranged sister. It's not guaranteed that it would be, Stephanie or Andrew or the niece and nephew, which is really, if that happens, is not at all what Jason would have wanted, right? All right, so that process happens, and then a couple years later, Jason ultimately winds up passing away. This is when Jason's will is going to come into the picture, and if we remember, in his will, he had left his estate to Mark, but only if Mark survived, and otherwise, a portion of the estate would go to his favorite charity, and then the remaining assets would go to his niece and nephew, Stephanie and Andrew, in equal shares. However, in order for those three parties to actually inherit those assets, what do you think is going to be required under this will? It's going to be one final probate proceeding, right, for that family, with all the expense and the time, etc., involved in that process. So ultimately, these wills that we've been describing have turned out to be a pretty expensive estate plan so far, right? With the combined costs of like the nursing home stays for Jason, the court proceedings, etc. These wills have actually wound up costing Mark and Jason and their estate a little more than $300,000 over time. So now we're at that time frame when the beneficiaries, right, the niece and nephew, Andrew and Stephanie, are each set to inherit from Jason, okay, after the probate process is done. And they're each then set to just receive a lump sum, what we call an outright distribution, of probably about like $600,000 or $700,000 each. And so there are some concerns that, Jason or an aunt, an uncle, a mom, a dad, whatever, might have about your beneficiaries inheriting such a large amount of money all at one time. Maybe they're just young, maybe they're not good with money, maybe they have creditors. And in this niece and nephew of Jason's case, Stephanie and Andrew, there are some issues as well. I know Stephanie, I described her kind of at the beginning as that's the good girl of the family, but she did have kind of one decision that her uncle never really agreed with, and that was in who she married. So she's married to this man named Charlie, and Jason and Mark never really liked Charlie or agreed with her marrying him. But they didn't do anything in their estate plan to address this issue. They didn't know to. So when Stephanie receives her, let's say, $600,000 inheritance, she does what many married couples do, and she deposits that money into her joint account with her husband, Charlie. 5 or 6 years go by, Stephanie gets fed up and decides to divorce Charlie. Well, guess who's walking away with half of that inheritance? Charlie is. Definitely a result that Jason and Mark would not have wanted. The nephew, Andrew, on the other hand, has some different issues. I mentioned at the beginning, he's had issues with addiction, and he actually failed to file his tax returns for several years. So he has a pretty hefty IRS lien. So when he deposits his inheritance, the IRS just reaches right into his account and takes what they're owed. Again, this was an issue that Jason and Mark were kind of aware was a possibility with Andrew, but they didn't know to do anything and provide any protection around this issue in their estate plan. And it's too late to do anything about it now for either of these beneficiaries. Once we get to this point, there's nothing that can be done to protect these inheritances for this niece and nephew. All right, so ultimately, I think we can see, and kind of the point, obviously, of this example of these wills is really to show you how ineffective a will plan really is and can be. A will in and of itself really does not provide the protection that is needed as far as during somebody's lifetime, if an incapacity happens with regard to court, nursing homes, etc. And, kind of same thing at death. So you probably all are wondering, well, why have we been talking about wills for so long, since they're really not a super effective way of doing estate planning? Is there a better alternative? And then we're going to get into that in just about now. But it is important, really, I think, to show you how, really get into the nitty-gritty of how a will works and probate and all that stuff, because it really does highlight the alternative, which is a living trust. And it highlights why it is such a better alternative than a will is. So I'm going to now pass it back on to Bridget, and she is going to take us through our next fictional couple who decides to actually get some trust done.
Awesome. Thank you, Miranda.
Welcome. Let me give you control.
Right. Yeah, don't cut us totally off like I did.
Okay, there we go.
So I'm going to pick it up from here because Miranda very effectively gave us the context of what traditional planning is. That sort of will plan that, as you can see, costs a lot of money, brings some chaos and confusion, and ultimately in court. So we get this question all the time: what is a living trust? How does it work? So I'm going to walk you through it, again, with also sort of fictional characters who are going to help us sort of trying to move the screens. Okay. Oh, here we go. Who are going to help us put this all in context. So I want to introduce you to Alex and Liz. They've been together for 20 years. Even though marriage became legal, they decided not to get married for their own reasons. And they have their fabulous puppy Lucky as well in their life. And as far as their family is concerned, Liz has a daughter. Her name is Rachel, and she and her husband have a young child. So Liz has a grandson, and she likes Rachel's husband, but he has had a struggling business. And so Liz and Alex have had to kind of supplement his lifestyle and their lifestyle with loans. So over time, just as some background. Alex doesn't have any children, but she has a niece that she's been very close to since she was a child. Her sister died young, And so she has kind of slipped into that mother figure for her niece, Sam. And Sam was doing really well for a long time, but unfortunately in her early 20s or her young adulthood, ran into some trouble, some, alcohol addiction, has gotten a DUI, and Liz and Alex have had to bail her out of some things, but there is still potential for her to turn it around. So they are hopeful for young Sam. So that's the context for Liz and Alex, and they do have a to-do list, and on their to-do list is actually to create a living trust. So let's have a little conversation about a living trust. Are all living trusts the same? I am here to tell you, after 20 years, they are not. Miranda mentioned this, I mentioned this earlier. We see what we call bare bones living trusts. These may be created by attorneys. They may be a do-it-yourself thing online with like LegalZoom or who's the financial advisor who has software to create a trust. The problem is they are often just generated as a general for any one size fits all. You plug in a name and you plug in your distribution, what you want and who you want to be the trustee and all the different roles, but there is no guidance as to why you should put that in there, how you should put things in, or how you put assets in or fund. So oftentimes these are very inadequate documents that land families back in court anyway. They fail most of the time, and frankly just really ignore any real world issues that many of our families have, because there's places in life you don't want to be the unique one, but here it's okay in estate planning, because a plan can be geared for your family if you have unique circumstances. So we advocate more of a legacy protection type of planning, which I mentioned earlier, of how we take everything into consideration, the life, the things that are happening inside of the family, and plug that into finances so that we have this very cohesive plan for now and the future. But ultimately, the most important thing about a trust that's different than that traditional plan and magical is that you avoid probate, right? And the way that we avoid probate is, while you're alive, we create this plan to deal with things if you become incapacitated and die, but two, we transfer assets that you have into the trust so that the trust is on title to your house, to your bank accounts, to your investment accounts. And so in this case, that's what we do with Liz and Alex. Something I forgot to mention that I should point out too is that Liz and Alex are going to get mirroring trusts. Because they're not married, we are not creating one trust agreement. They're going to have trusts for their assets that are separate, and we are going to have different distributions for those that we'll see later. But so Alex and Liz, because they're not married, will get two separate trusts. Regardless, we're going to fund it. So we're going to transfer all of Alex's property into Alex's trust, and we're going to transfer all of Liz's property into Liz's trust, and we're going to title all of that joint property equally in both their trusts. Now, one fear clients sometimes have is like, oh my gosh, I'm taking my name off something and I'm putting this trust name on it. Do I lose control? Like, can I sell this asset? Can I refinance my property? Those types of things. And the answer is you do not, absolutely do not lose control, because inside of both those trusts, you occupy every role in there. You are the creator of that trust. You are the trustee, so the manager while you're alive and competent, and you're the primary beneficiary while you're alive. So combining all of these things means basically not a ton of things change. Both Liz and Alex have control over all of their separate assets, and they have the same amount of control they would have had they not put these in place over their joint property assets. They also can, if they change their mind on, so their life goes on business as usual in terms of acquiring assets, selling assets. They just need to be conscious about how they're titling things. But for the most part, also, while they're alive and competent, if they change their mind about a distribution or about a role, they can amend the trust. They can revoke the trust. So it really changes very little for them. Their house is not going to get reassessed. Their income taxes every year are filed the same way they've always been filing it. So nothing changes, and the trust really acts as what we call a standby device. So it is waiting to protect them and their family for those unfortunate events that occur that we saw earlier. And at incapacity, at death, there will be a plan and no court involvement will occur. So it not only protects each other, both Liz and Alex are protecting each other, they're protecting their loved ones, and they're protecting them generationally. So let's see how these work in action. So in the case of Liz's trust, both she and Alex are trustees of this trust, and they are the primary beneficiaries of this trust. So if Liz dies first, Alex immediately steps into a trustee role and a beneficiary role in Liz's trust. So she is controlling all of their assets, hers, Liz's, and their joint asset. And then when Alex dies as the second to die, then those assets get distributed as they agreed upon, half going for Rachel and half going to Sam. For Alex's trust, we do kind of a mirroring thing. We don't kind of, it is a mirroring thing. So Alex and Liz are both trustees on this trust. They are the primary beneficiaries. And if Alex died first, then everything goes to Liz. Liz now controls her separate stuff in her trust. She controls everything in Alex's trust, and she controls everything that is joint. So then, that is kind of how it happens. So all of their assets, even though they're represented in two trusts, go to the beneficiaries as they agreed upon equally. So let's see how this also works in the event of not a death, just an incapacity. So on a rainy night, a drunk driver runs a red light and Alex suffers a closed head injury, so a brain injury, which she is still relatively functional, but she cannot manage her financial affairs and can't really care for herself and sometimes even make health decisions. In the prior example that Miranda had, those gentlemen, had to go to court to get control over their partner's stuff, even though they were married. In this case, with a trust, marriage or not, Liz is able to manage Alex's things. And when Alex dies, Liz, as we pointed out before, is able to administer her trust, and she is able to get the benefits of Alex's assets. So it would be as if Alex didn't die. All of those assets are available to her, and she doesn't even have to go to court for a probate to do that. In the case of one of them remarrying, so if Alex decides to remarry, then there are protections in Liz's trust that would protect assets for the beneficiaries. So Alex can use them, but she cannot change any of the terms of that trust, so that when she dies, it will still go to Rachel and Sam, all those assets, and vice versa. But let's say while Liz is alive, she gets, so Alex is dead, Liz is alive. Liz finds herself in a situation where she has a cognitive decline. And unlike Rachel, who's the successor trustee, having to go to court to get control of her mom's assets and to pay for her care and make her health decisions, it is already built into the plan. So Rachel very smoothly steps into the role of trustee and protects everything for Liz. So she's able to manage not only her health care, but all of her assets to pay for that care without any need to go to court to establish anything. So there are no delays. The money is not spent on fees and court costs, and Rachel is able to manage her mother's care. And what about Lucky? So you can also plug into these into these plans, and Alex and Liz did do that, so that Rachel has money out of Alex's and Liz's trust that will help care for Lucky if needed. Vet bills, food, training, whatever it is his care is required, that is covered and not coming out of Rachel's pocket. But what about the costs of, Liz's nursing home stay? As we know, it's very expensive, and they wanted to avoid those costs. Well, there are tools set up in the original trust that they create, in the original plans that they created, where Rachel can step in the role of trustee and move assets around in order to qualify for Medi-Cal or any other sort of income-based or asset-based programs that would help supplement long-term care. This is a whole nother educational piece to go into, like, how Medi-Cal helps and can step in for care. But essentially, the assets in the trust are protected by Rachel. She's able to move money around if she needs to help supplement care, and she's able to make all the health decisions needed to get to get Liz the care that she needs. So when Liz dies, well, will Alex's and Liz's trust go into probate? No, because they're both still existing. Rachel is taking care of both of those trusts and the assets inside of them for the benefit of Liz while she is alive. But when she dies, it all gets distributed. And remember, we were worried a little bit about Sam. She's kind of not gotten out of this phase or this addiction problem, but we knew that there is, Alex was sure that there was some help for her in the future and there was possibilities. And same with Rachel. So Liz really wanted to protect that Rachel, Liz really wanted to protect that Rachel doesn't get, if she gets in a divorce, everything she inherits doesn't go to the husband, and that she can keep her inheritance or to keep his business going. So she gets choice over that. So inside of a trust, we can set up sub-trusts for the benefit of these two beneficiaries that have some issues facing them, but we hope that we can give them the tools and the support that it can be overcome, and those assets will be used for their benefit, which is what Alex and Liz's original intent was for this plan. So in the case of Sam, her share goes into what we call a family century trust. And in the case of Rachel, her share goes into a family access trust. So what is the family access trust? Well, we kind of coined the name a divorce trust here in the office. And what it does is it allows her share to drop into a sub-trust for her that she is the trustee of, she is the main beneficiary of, but it keeps it her separate property. And in case something were to happen to her, her husband doesn't automatically inherit that money. It actually goes in trust for her young son and is taken care of either by the dad, so her husband could be the trustee for her son, but that money is preserved for Liz's bloodline, right? The other benefit of it is that if Rachel were ever to divorce her husband, those assets are clearly separate property, and under California law, she would keep those assets and they would not be divided and half of it trot off to the husband in a divorce. So very helpful subtrust. Then in the case of Sam, we want to have somewhat of a century on that, right? So we want Sam to have the availability of that money if she needs it for rehab or for living expenses while she's getting on her feet again and she's gotten sober and kind of turned her life around and got a good paying job, but needs just a little bit more for rent. So this is an irrevocable trust which has an independent trustee. The example before, Rachel can be her own trustee. We trust Rachel with the money. We just want to make sure that it stays with her and it doesn't get trotted off in a divorce. But in the case of Sam, we need to control those funds a little because giving her the whole $700,000 can be very destructive. So you're going to need a third-party trustee. So the third-party trustee might be Rachel, the third-party trustee may be a bank, but long story short, Sam needs to ask for someone for money, and that person has discretion about what money is used for in her trust. So it protects her if she has some crazy marriage and goes to Las Vegas and gets married to someone and then divorces, 2 months later. It protects those assets from any creditors she has picked up along the way or any lawsuits. But she doesn't have to live like that forever with this third-party trustee asking for money. We can build incentives in there. So Alex can build incentives in there that if she, got sober and was sober for a certain amount of time, or gainfully employed, or got an advanced degree, or whatever it is, has dealt with those issues that have gotten her way and cleans up her act, the trustee could give her the remaining part of those assets for her to control outright. Then there's another type of subtrust that we see fairly commonly that is not in this scenario of Alex and Liz, and that's a special needs trust. So any family out there that has a child that is taking advantage of any government entitlements, you know that if they inherit a large sum of money, that they may be bounced off of those entitlements. So this allows this subtrust to hold those assets and conform with the government requirements, but still have money available or their inheritance available for any special needs they may have. Travel, a new computer, a new car, even buying a house, so that it will not jeopardize any of their governmental benefits that they're getting if they were to inherit. When in some cases, if it just goes outright, it's too late to protect those monies. So it's very good to get this trust, in general in line. But if you have a special needs beneficiary, that protects from the government taking all of those assets from that child or them losing those benefits. Then, of course, we're taking care of Lucky. So what happens with Lucky is we set aside $20,000 for his care. And so even while either of them are alive, he's cared for. So after Alex's death, and when Liz was incapacitated, Lucky was getting cared for with that money. And after both of them dies, if Rachel can't keep Lucky or Sam can't keep Lucky and they need to give him a new loving home, that money can go with him to help relieve the burden of taking on the pet. There's many different ways you could do a pet trust as well, so that money is managed. But it's an option to care for your pet long after you've passed away and have some peace of mind that they're getting the vet care that they need and the food that they need. All right, so we have one more defining moment, ladies and gentlemen, tonight, and that is, how will you be remembered? You are a defining moment in your loved ones' lives, right? Something happens to you, and that means something. Everything we do has a ripple effect in life. So what most people leave behind are disputes and fights, court hassles, fees, confusion, stress. But if you do this right and you put a sturdy plan in place and you care about your legacy and you're a good steward, then you can create memories that are very smooth and loving and just really dial down the stress level of when these events occur and how we're dealing with it. So how do we do it at our law firm? How does this get in place? This is the action plan, folks, that we talked about earlier. And we have a 5-meeting system, basically. It's 6 steps, but 5 meetings with the attorneys or staff. And the first is your personal consultation. So you're getting an opportunity tonight to have a free consult with Miranda or I, and in that meeting, we're going to find out more about you, and we're going to start putting the building blocks of your plan in place. Your next appointment is a review of all your assets, which are important to know because not only do we need to list them in the trust, but we also need to make sure that those are going to get retitled into the trust. Finally, your that appointment is just refining what you've decided your plan to be, what roles are going to be filled by whom, and where are your assets going to go at the end of the day after you or both of you pass away. Then in meeting 4, we realize how important it is that assets and wealth be coordinated with your estate plan. So we're going to give a careful review of your assets and your investments, And we're going to make sure that that plan has the best chance of functioning in the future. And we're going to have a conversation about it at that meeting. And then finally, in meeting 5, you're going to discuss, or you're going to sign everything. Actually, it's completed. Everything's going to get signed, scanned, delivered back to you. And then the 6th step, which I think is probably one of the most important things, is that we maintain regular communication. So from our office, you're going to get educational webinars on many different topics like long-term care, your healthcare directive, what happens after someone dies, and trustee school. All of these things are available to our clients and their loved ones. Not only that, every 3 years, we bring you in for a free appointment to review your assets, your plan, your family, and to make sure everything is correct and in place and functioning and will function when needed. So how do I make this happen? What are the next steps? And how much do I have to pay to get this done right? Well, our fees include all the documents that are needed in your plan, anything you might need, and any decision that anybody needs to make is included in this plan. Not only the trust, but healthcare directives, durable powers of attorney, so that any problem or any issue that comes up, we have a plan for it. Once you have signed all of your documents, or excuse me, before you sign, we also give you a personalized plan review. So it will be your trust, article by article, what it means, the decisions you've made, the roles you've chosen. And you will have that, for as long as you want to. So you can use it to review your trust, you can use it to share it with others. And then once you've signed, we take all of those original documents in their PDF form and we put it on a USB drive so that it is always at your fingertips. If you need your health care directive to give to your doctor or your health plan, or you want to share everything with your successor trustee, it's easy to do and you can do it digitally. So what if things change after we put this whole plan together? Because they will. There's changes in the law, there's changes in your life, there's changes in new legal strategies, there's changes, happening all the time. We are committed to keeping your plan up to date and supporting you in doing that. And that's why we have this long-term relationship and these 3-year reviews. So when you asked yourself earlier on in this webinar, what is the most important part of your planning? Do you remember that answer? Because that'll be important when we come to our first meeting, because we want to cover what is most important to you and your partner. Listen, you really get a shot at this once, and you want to get it done right. Like I said early on, you don't get any second chances at this. Because when things start happening, it is too late to make these plans or change your mind around it. So it is not worth, saving a penny to get a bare bones trust when you don't know for sure if it's going to work, or if you even have the support of a professional to make sure that it gets done in the correct way. You want a plan designed for your family that is going to work and is around that idea of what's most important to you, because and we know that this can last generations, not just you, not just your partner, but all of your loved ones and grandchildren, grandnieces, grandnephews. And the truth is most plans don't work because even though they may be beautifully drafted by a lawyer and everything else, people don't do the follow-up needed to make that plan work, which is transfer assets into the title of the trust. That is something we make sure gets done, because after 20 years of doing this, we know that it is a beautiful pen with no ink. If you have not done that, the whole plan, whatever money you spent on it, is worthless. So don't be fooled. Creating this plan, you're going to need some wisdom, you're going to need some expertise, you're going to need some accountability, someone to be persistent with getting it done and getting it done right. And it's going to take a little time, not forever, but it'll be worth the time. So you want to get it done right, and you want to get it done with people that know how to get it done right. And like I said, there are no second chances in this realm. So let's talk about fees. How much is the cost of failing to plan? Well, we're really pretty clear on that from Miranda's section of this educational webinar. You know, it could be $250,000 to $500,000 sometimes of not getting it planned right. Court, in and out of court, stress, sadness, very few resources to help you. So we kind of look at this planning a lot like you would look at surgery, parachutes, fire extinguishers. You need them at the moment you need them. When you're ready to go forward, that you be ready to also do those things as well. Yeah, so that is everything. Really ask yourself, you know, do you want that first scenario, the will plan that Miranda described, or do you want Alex and Liz's plan where everything went smoothly and they could even take care of things that they were worried they couldn't have with Rachel and Sam? It's up to you. And we hope that you choose a path of leaving a legacy and being a good steward of your assets and your life. Any questions?
All right, thank you both so much for that presentation. We'll open it up to questions now, so you can type something into the Q&A, you can raise your hand, or you can use the chat. So let me go to the first question typed into the Q&A. What are the issues and expenses associated with selling or borrowing against real estate that is titled in the name of the living trust?
Good question. You know, there really aren't any expenses associated with that, except for if you're in the case of borrowing any of the, you know, lender's expenses for getting that loan. And some of the issues that can arise is if you have a house in the trust and you're borrowing against it, sometimes the lender will take it out of the trust and want it in your name so that they can fund the loan. And then they should put it back in the trust. So that is one issue that sometimes comes up. The home is not put back in the trust after the loan is registered, and we help clients go back and do it. But most of our clients are educated to request that at escrow, and 99% of the time, escrow and the lender will put it back in the trust without a problem. Do you want to add anything, Miranda?
No, I mean, I think just otherwise, like selling a property from the trust is really the same process as selling it as an individual person. You know, it's still you as the trustee of your trust that are signing the paperwork. So it's really basically the same kind of process, apart from what Bridget mentioned on the, you know, the refinance or borrowing against it. So there's no additional expenses, and really the purpose and, you know, the point of the trust is it's not meant to have a big, you know, impact on your life once you create it, right? You're still basically, like, once it's funded, you're really just interacting with your assets in the same way that you always have.
Yeah.
Good question.
Very good.
Thank you. Here's one from the chat. Does your set fee include all future changes that might arise?
You want to take that one?
Yeah. So no, it doesn't include all future changes. So basically what our set fee includes, you know, in addition to just the creation of the plan and assistance with funding of the plan, is once you become a client, you know, we offer a lot, you know, 3-year review appointments, and those appointments are complimentary. And basically, like, we don't charge hourly really ever. So like if you have a call with us, you have a question about something, an email, 3-year review appointment, or just an appointment in between because, you know, maybe you have questions about something, we don't charge for that. If there's actual further legal work that needs to be done, like an amendment to your trust, you know, changing the beneficiaries, changing the successor trustee, we do charge for that, and we always charge by flat fee, so we'll always let you know what that cost is in advance. And then, you know, as your plan, as events happen in life, like an incapacity happens, a death happens, and the trust needs to be administered, we help with that as well, and, you know, represent either their surviving spouse or the successor trustee, kind of whatever the scenario is. And, you know, we charge for that service as well. A lot of times, and by the way, I'll just add, like, what people think are require a change to their trust often don't actually require change. So most of the time, like asset changes, that's really just a conversation and a question around titling. It doesn't require an actual change to the documents. Anything to add, Bridget, to that?
Yeah, I was just going to say that, you know, the bulk of questions we get are like, I have this new account, or we sold that vacation property, and do I need to amend my trust for that? And absolutely not. You don't. Those are things that just need the bank account, needs to get the trust name on it, and if something came out of the trust or out of title of the trust, that's okay. You don't need to change it.
Yeah.
Thank you. And another question in the chat. I already have a trust, but my attorney retired and I'd like to work with your firm. Can I make an amendment?
Yeah, that's a great question. We get it a lot. And the short answer is no, we won't make an amendment to another attorney's trust or any other trust that comes into our office. So, and the reason is for us to go through that existing trust, and sometimes they're old, sometimes they're new, for us to go through line by line, article by article, to look at that trust for what you think is a simple change, like I just want to change out my trustee, I want to, you know, put one more beneficiary in and give a gift. It seems simple on the surface to you, but for us, it's someone else's document, and we have standards of what we know documents perform at when they need to perform. A lot of it's under the hood, and most of the time when we see those prior documents, those things aren't in it. So we'll want to change all of those things as well, because you would become our client, and you know, we're going to be updating it from that point forward, all of those things. So what we end up doing is a restatement, and it's actually the same fee as getting a new trust. And it's actually less than what it would take for Miranda and I at an hourly rate to clean up or make a correct amendment, even though there's one thing you think you need to change in that trust. So that is the short answer. We don't do an amendment. We would ask you, or we would require you to work with us to do a restatement. And the upside of it is you wouldn't have to retitle any assets that were in that prior trust. The name of the trust would remain the same. We would just update and make your change and update and bring everything up to standard in the remaining documents.
All right, thank you. Do we have any other questions?
Looks like it. All right, well, thank you everyone so much for joining us tonight. I know we went a little over in time. This is a really meaty area. There's, you know, there's a lot of considerations that go into it, as you can tell. But we're really glad you joined us. We hope you will make an appointment. I'm sure we'll be reaching out to all of you tomorrow. And do we have a Calendly link popping up, Rachel?
There yes, it is. Calendly link's there.
Okay. Just dropped it in the chat as well.
Awesome. Yeah, so we hope to see you at an appointment, and have a good night.
Yeah, thanks everyone.
Bye.